Now, without further ado, I'd like to invite John Trehey, Juno Huang, and Karen Zhang Pallaras from Maples Group to begin their first session. I'll do quick introductions. John is the head of Maples and Calder's Asia Dispute Resolution and Insolvency teams. In addition, he advises on all aspects of mergers and acquisitions, banking, and general corporate matters. He has a broad international client base comprised of major corporates, financial institutions, and insolvency-related office holders. His expertise covers both Cayman Islands and British Virgin Islands law. Thank you for joining, John. Good to see you. Then we also have Juno Huang, who's a partner at Maples and Calder's corporate team in Maples Group Hong Kong office. Her practice covers a broad range of corporate and finance matters involving Cayman Islands and British Virgin Island companies, including private equity and venture capital investments, joint ventures, pre-IPO financing, reorganizations and restructurings, debt capital market transactions, M&A, banking and financing with particular focus on IPO, and listing of shares of Cayman Island companies in Hong Kong, Taiwan, and US. Thank you very much, Juno. Good to see you. And like Juno, we have Karen, who's also a partner of Maples and Calder's corporate team in the Maples Group Hong Kong office. Her practice covers a broad range of corporate transactions involving Cayman Islands and British Virgin Islands companies, including M&A, pre-IPO financing, initial and secondary public offerings, private equity investments, joint ventures, reorganizations, and restructuring. And she has extensive experience advising on significant and market-leading M&A and take-private transactions involving Hong Kong and US-listed company. Karen is fluent in Mandarin and Shanghainese. Good to see you all. Thank you very much. And you can start sharing your screen. And all the best. Thank you very much.
Thank you, Rao, and for the kind introduction. And thank you for everyone who's able to attend today's session today. We're very excited to share our knowledge on how to navigate through Cayman and BVI mergers. But before we dive right into it, we just wanted to mention a couple of lines about Maples Group, especially for those who don't already work with Maples. Maples Group is a service provider in the financial services industry. Vast of the majority of the public probably know us from deals that we act as BVI and Cayman legal counsels on the deals. But other than our provisions of the legal services, we also provide fiduciary, fund, and regulatory and entity formation and management services. Maples was founded in the Cayman Islands in 1967, started by two gentlemen called Mr. Maples and Mr. McDonald's. They started their business in the caravan. And today, we have grown from a two-person partnership to a team of lawyers composed of more than 2,000 lawyers and professionals worldwide. We have 16 offices around the world. And this year, we celebrate our 26 years in Hong Kong. Maples, as a group, can advise on laws of 6 jurisdictions, namely Cayman Islands, British Virgin Islands, Ireland, Jersey, Luxembourg. However, out of our Hong Kong office, we tend to advise on the laws of 4 jurisdictions, Cayman Islands, British Virgin Islands, Marshall Islands, and Ireland. This is because our clients in the Greater China regions don't tend to use Jersey and Luxembourg as much. But I think in the recent year, there's a growing trend for clients that seek to invest in the EU. So there's increasing inquiries on Jersey and Luxembourg law. So if anyone actually has any queries in relation to Luxembourg and Jersey, please do feel free to get in touch with any one of us in this session. And I'm pretty sure we'll be able to put you guys in touch with the relevant experts in Maples Group. Other than legal services, I see that from the attendees list that some of you may have worked in asset management companies. So I would no doubtly believe that you would be familiar with our fund services. So other than advising on the fund formations and launch of funds, we generally provide middle and back office supports to assist with the daily operations of the funds. We can also assist with fund accounting and preparation of financial statements and just general investor services. Lastly, but not least, we also assist with entity formations. Most of people know us as to be able to assist incorporation of Cayman and BVI companies, but we actually can incorporate jurisdictions such as Hong Kong, Singapore, Bermuda, UK, Holland. So and also 52 states of the United States. Basically anything that you can think of or need throughout the life of a company or a fund, then Maples can provide such services. So if you are ever in doubt, please do reach out to one of the usual contacts at Maples Group or one of us in a presentation, and we'll be very happy to assist you. So what is Maples' role in the context of an M&A transaction? Maples typically act as the Cayman and BVI counsels that support onshore counsels on the M&A transactions. We would be consulted on specific Cayman and BVI elements of the deal, right from the very beginning of the structuring stage up to the closing of the deal. And Maples' strategies are always being strategized to provide one-stop shop. So typically, if we're acting for the bidder, we'll be assisting with the incorporation of a Cayman or BVI parents and mergers up, and we'll be assisting with the merger filing on the effective date. This is particularly important because on occasion that where we are just acting as the deal counsel and we are not the registered agent for the constituent companies, sometimes there will be occasions where the registered agents would miss out on the filing. And if the merger filing is not filed, then the merger would not be effective. So it is important for us to, for Maples to be involved from the beginning, and so that we have full control of the entire process of the merger process. We also advise on the position under the applicable Cayman and BVI statutes. We also advise on, common law issues where particular issues arising with director fiduciary duties. We would also assist with the review and the commenting of the deal documentation, depending on the type of the structure that is followed. What we don't do is we don't really take part in the commercial negotiation of the deals. Sometimes people are not aware of our role as offshore counsels and would ask us to, negotiate or, draft merger agreements. But this is not something we typically do as offshore counsels. We tend to just be the support role to the onshore counsels and, answer any questions which is relevant. We do prepare documentations which is required under the statute, such as the plan of merger, the relevant corporate authorization documents, such as shareholders' resolutions, board resolutions, directors' declarations, and we would also attend to the post-closing compliance. So as mentioned before, if we are the registered agent and we keep the registered members, then we could assist with the minute book updates, in particular with the register updates where the merger involves issue of shares as an exchange or consideration for the merger. So what are mergers? The Cayman Islands introduced a statutory regime in May based on the Delaware statutory merger regime. In a merger, one or more constituent companies would get subsumed into another constituent company and becomes the surviving entity. What happens then, all the rights and obligations or the assets or the shows as in action liabilities would then vest in the surviving entity. The Cayman merger regime is particularly designed to provide a very straightforward and non-court driven process to allow companies to merge. Even Cayman companies or BVI companies can merge with foreign companies, provided that the merger is permitted by or is not contrary against the laws of the jurisdiction of the incorporation of the foreign company. BVI or Cayman companies can also merge with foreign companies, where either a Cayman company or a foreign company can be the surviving entity. Given the lower voting threshold, which is the 2/3 of the approvals or the such other higher approval as required under the articles of association of the constituent company, the merger regime are usually very popular alternative to a scheme of arrangement or squeeze out following a takeover offer. They are particularly popular for taking private, publicly listed Cayman companies, private, and in particular where US listed companies, which Karen will elaborate further on. On the other hand, Cayman companies listed on the Hong Kong Stock Exchange are typically taken private by way of scheme of arrangement or a general voluntary general offer or a compulsory acquisition, which we usually call a squeeze out. Because as far as we are aware, the Hong Kong law does not yet recognize the concept of mergers. In a merger, the shareholders are typically entitled to object to the merger. And if they do, the dissenting shareholders' only interest with respect to the company will be the payment of a fair value for its shares. And John will cover the dissenting shareholders' rights in the later part of this session. So as you can see from the slides, the legal effect of a merger is that all the rights, properties, goodwills, benefits, claims, liabilities, convictions, judgments would vest in the surviving entity. And for those non-surviving constituent company, it could be one or two if you merge more than two companies together. These non-surviving constituent companies would be struck off from the register of companies with effect from the merger. So this is the chart where you can see two constituent companies where they would merge and surviving company will become, the constituent company 2 will become the surviving company. Constituent company 1 will be dissolved. So the Cayman merger regime is quite flexible in terms of the terms of the consideration. Some of the shares in each constituent company may be converted into or exchanged for different types of properties, and that includes shares, debt, obligations, or other securities of the surviving company or other corporate entities in the surviving company. Some examples include cash consideration, share consideration, or a combination of shares and cash. From examples here, you can see from this chart, the bidder company would usually set up a wholly owned subsidiary called parent. Parent would then set up a merger sub, this merging company. And merging company would merge with the target being the surviving company. The shareholders of the surviving company will walk away with cash and their shares will be cancelled. The effect of this merger means that the parents will hold the target directly and the shareholders here walk away with the money. In the second examples, the merger consideration is shares. So instead of receiving cash, the shareholders of the surviving entity will receive shares of the parent. So the end result would be the shareholders would hold shares of the parent and parent would hold the surviving company. So in what context are mergers often used? As I mentioned before, they are used most often in listed companies, especially companies that are listed on the US, and they're used in the take-private transaction by private equity and management. Sometimes they will be used for traditional strategic corporate acquisitions, such as companies who want to integrate their supply chains. We have come across situations where the Cayman company would merge with a Delaware entity or California entities, just because they provide certain kind of service or technologies that the bidders required. And no doubt you would have heard something what's very, very popular at the moment is the de-SPAC. Merger is very common in a de-SPAC transactions where the SPAC will identify the target and they will undergo a business combination which involve a merger. This is mergers often used in internal group restructurings. So to achieve certain onshore tax benefits. In the scenario, it would be Cayman parents would merge with a Cayman subsidiary, and in that context, a special resolution is not required if the copy of the plan of merger is given to every shareholders of each subsidiary company. A parent company means a company that owns at least 90% of the issued shares in the class that's entitled to vote. And I will hand my microphone to Karen.
Thanks, Juno. So now we're talking about mergers in the context of take private of a US listed company. So as Cayman statutory merger is the most common form of structure used to take a US listed Cayman incorporated company private. So the process is that a buy consortium will make an offer to the listed US listed target company to purchase all of its issued shares. So the buy consortium would usually consist of the existing directors, management, majority shareholders, and PE houses and their affiliates. The transaction is structured through the merger of the target company with a newly incorporated SPV, wholly owned by the buyer consortium, and what we would often refer to as the merger sub. So if we look at the structure before the take private, the buyer consortium will usually incorporate two new SPVs. The parent sitting on top wholly owns the merger sub. The members of the buyer consortium would invest into the parent. So at the parent level, there will be some form of investment agreement or shareholders agreement governing the shareholding and the rights of the members of the buyer consortium. On the other side, you've got the target company that is listed in the US. On the level above the listco are the shareholders who are registered on the register of members of the listco. So unlike a Hong Kong listed company where the shares of the listco is directly traded in public, for a US listed company, the listco would issue shares to the ADS Depository Bank. The ADS Depository Bank would in turn use the underlying shares of the listco to issue American depository shares under a New York law-governed deposit agreement. So American depository shares, or ADSs, are in effect US law-governed contractual arrangement. So these two smiley faces above the ADS Depository Bank in the structure represent the ADS holders. So as part of the merger transaction, the merger sub will merge with and into the listco, with the listco being the surviving company. The merger sub will be struck off and cease to exist, and the shareholders and the ADS holders that sit above the listco will have their shares and ADSs cancelled in exchange for an agreed merger consideration per share or per ADS, usually in cash. But sometimes it could be a combination of cash and shares. This results in the aftertake private structure, with the buyer consortium sitting at the top, wholly owning the parent, and parent becoming the sole parent of the listco, which is now a privately owned company. So Cayman statutory merger is very popular for a US take private because the merger provisions are substantially similar to the merger statutory provisions that are used in Delaware and several of the other US states. So US parties, investors are quite familiar with the Cayman statutory provisions. The regime allows a Cayman company listed on a foreign stock exchange to be taken private without the need to get unanimous shareholder consent or seek Cayman court approval. So as I mentioned before, the buyer consortium would often consist of existing majority shareholders, investors of the target company and their affiliates. So these parties are interested parties. So as part of a merger, the interested parties are not required to abstain, and they are entitled to vote in favour of the merger and be counted in the special resolution required to approve the merger. So overall, the Cayman merger regime offers a relatively straightforward and speedy process for a listed company to be taken private. Generally, it takes about 2 to 4 months between the signing of the merger agreement to the consummation of the merger and closing of the take private. There is a caveat to this, as in recent years, we have seen more dissenting shareholder claims, which came out of these US take private. This is because under the Companies Act, shareholders who are of the view that the merger consideration offered by the buy consortium does not represent fair value for their shares have the right to dissent from the merger and seek payment of fair value for their shares in court. So what happens is the dissenting shareholders will need to deliver a written notice of objection to the target company before the vote on the merger by the shareholders. Once they do that, they actually lose their rights as a shareholder of the target company, and their only right to their shares would be to receive the fair value of their shares as determined by court. So my colleague John will discuss this point in detail later on in the presentation. The key commercial document in the US take private is the merger agreement, which sets out the terms and conditions of the deal, treatment of each classes of shares of both company, treatment of options and convertible securities. It would contain reps and warranties, covenants, and usually irrevocable undertaking from substantial shareholders of the target company to vote in favour of the merger. In the last few years, there have also been certain provisions that have been developed for the company, for the board of directors of the target company and the special committee of the board to demonstrate that they have established a robust process in evaluating the fairness of the price offered for the shares by the buy consortium. So some examples of those provisions include fiduciary outs, which is the type of provision that would allow the board of directors of the target to terminate the merger agreement if there is a superior offer by a third party. Another example is the go shop, where the board of directors can go and find competing deals. A key aspect of the US take private deal from Cayman law perspective is the directors' duties. So the plan of merger must be approved by the directors, and often existing directors are also members of the buy consortium. So there would be a potential conflict of interest. While not legally required, where the management are potentially interested, it is prudent for the target board to appoint a special committee of independent and disinterested directors to evaluate the take private proposal. In particular, the most important thing they need to consider is the fairness of the purchase price offered in the transaction, and to support its decision in recommending to the board of the target whether to pursue or reject the offer from the buy consortium. So in doing that, in appointing the special committee, members of the special committee, as well as all of the directors on the board, owe a fiduciary duty to the shareholders of the target to obtain the best value, the best price that they can reasonably obtain from the buyer group. So in order to demonstrate that they have properly evaluated the proposal from the buyer consortium, the special committee would often engage and the service of financial advisor to advise on and give an opinion on the fairness of the offer price. They would also negotiate certain provisions in the merger agreement, such as fiduciary outs and go shop, which I mentioned earlier on. A director of each of the merger sub and the target company is also required to sign a director's declaration. Amongst other things, the director is required to confirm that the company will be solvent immediately after the merger completion, and that the transaction will not be prejudicial to the existing creditors of the company. So the first milestone in the US take private is the signing of the merger agreement. Once the merger agreement is signed, the US councils will start preparing the preliminary proxy documents to be submitted to the SEC. And once those documents have been approved by the SEC, the target company will start setting record date to convene the extraordinary general meeting of the shareholders to obtain the authorization by shareholders of the plan of merger. Under Cayman law, the approval threshold for the merger is a special resolution, which is more than 2/3 of the votes cast at the EGM, plus any other authorization which is over and above the requirement of the special resolution, which is specifically set out in the target company's M&A. So once the company has convened the EGM and passed the special resolution, the parties will generally proceed towards the consummation of the merger and the take private closing as soon as possible. On the date of closing, the plan of merger and the supporting documents will be filed with the Cayman registrar. Usually we will get the certificate of merger either on the same day, on the closing day, or on the business day immediately following the closing. The merger will be effective on the date that the plan of merger is registered by the registrar, unless the plan of merger provides for a later date. The effects of a merger for a US take private is the same as any other Cayman merger, which Juno mentioned earlier. So everything belonging to the merger sub, all of the rights, mortgages, charges, proceedings, judgments, will be transferred and now vest in the target company, which is now the surviving company. Now, I've just got time today to very briefly go over the Cayman aspects of a take private. Obviously, a lot of these significant take private transactions involve many parties and US counsels and is quite time consuming and may span over several months. Maples Group has acted as Cayman counsel on many of the most high profile and significant take private transactions in Asia in the last few years. We have a lot of experience in acting for the company, special committee, and the buyer consortium, not only on the corporate side, the merger side, but also in terms of financing transactions undertaken by the buyer consortium in relation to the merger, as well as the investment by the buyer consortium into the parent. So I have just listed a few of the recent notable transactions that Maples have worked on in the last couple of years. And now I will pass to my colleague John to talk about dissenting shareholder rights and other mechanisms for implementing take private.
Good afternoon, everybody, and allow me to join the chorus of thank yous to all of you for turning out and participating this afternoon. It's a real privilege for Juno, Karen, and I to be able to come along and talk to you about some things that we're working on, which we hope are interesting to you and which we deal with on a day-to-day basis. Some of you, or perhaps none of you, might be wondering why a guy who heads up a restructuring, insolvency, and litigation team is talking about M&A stuff. Well, the answer to that's twofold. Number one, I'm involved on the contentious side insofar as these M&A transactions wind up in litigation in the Cayman Islands portal, whether we're supporting litigation in some other jurisdiction. And the other is that I actually have a reasonably significant M&A practice which complements my litigation, restructuring, and insolvency practice, which I first acquired in 2005 when I joined Maples. Back in those days, we were a much smaller undertaking with fewer people, and it tended to be the case when people went on holiday, they would toss their files to the junior to do. So I had a pretty steep learning curve. But in the course of those heady days back in 05, 06, 07, and even in the early stages of 2008, there was tons of this work to do. And so in the course of that, I managed to acquire and build, as I say, a fairly significant M&A practice, which continues to this day. And as recently as just a month or two ago, I was lead Cayman counsel on MBK's acquisition of Car Inc., the formerly Cayman company listed on the Hong Kong Stock Exchange. So with that brief addendum to my CV, I'll get right into my slides, Karen, if you kindly switch over to the next one for me. So I want to talk first about dissent rights, which complements what Karen was speaking about most recently in this presentation this afternoon. These only came into being in the Cayman Islands in and around 2010. When there was an amendment to our Companies Act in the Cayman Islands. And this was largely brought about by the fact that our US clients were demanding that we have legislation in Cayman that more or less reflected what they have in Delaware, where they do have a statutory merger mechanism. So we did. we wound up responding to those client demands and pressures, and we wound up putting into our principal companies legislation in Cayman statutory mergers provisions. And up until then, the only way anybody could take a listed Cayman Islands company private was to do it by way of scheme of arrangement or by general offer or tender offer and squeeze out, which I'll talk about on the next slide. So from about 2010 until 2015, we had this paradigm shift completely in relation to Cayman companies listed on US stock exchanges who now started to use the statutory merger as a mechanism for implementing their take privates rather than what they'd done before, which was the very cumbersome 130-year-old law in and around schemes of arrangement. And all was very peaceful, all was very happy. Clients loved the statutory merger process, loved the fact that they didn't have to go to court, loved the speed with which you could implement one of these until 2015, which was the first time a shareholder of a constituent company, in this case, a shareholder that had acquired shares in the listed company which was going private just before it was to go private and delist. And that shareholder acquired those shares for the express purpose of exercising dissent rights. So this was all very novel. We were actually, Maples and Calder acted for this particular dissenting shareholder, and I'm not telling tales out of school. This is all publicly available information. The company in question was called Integra. And what happened in Integra was that the dissenting shareholder in that case got a very, very favorable judgment. I think the uplift on the bid price, on the merger price, was about 19%, something like that, which is a very healthy premium if you've already invested several $1 million or more into the company in question. Now, that result precipitated what we would call the Cambrian explosion of merger dissent litigation in the Cayman Islands. It's been the biggest feature of Cayman Islands litigation now since 2015. It's ferociously contested. All of the major Cayman Islands law firms are involved in it in one way or the other. It's asymmetrical litigation, by which I mean most of the burden of the litigation in terms of evidence and disclosure, etc., is the company's burden, the going private or the gone private company's burden. But in essence, they're really just battles of experts or valuation experts. At trial, the testimony certainly back in 2015, 2016 was only the experts, one saying that the fair value is X and the other saying that the fair value was Y. But ferociously contested, and they still are. Almost all statutory mergers involving listed Cayman Islands companies on the US exchanges have had merger dissent litigation or pre-litigation action to whatever extent. Now, I'm, of course, specifically saying Cayman companies listed on the US exchanges because we haven't yet had a go private by way of statutory merger in Hong Kong. I think the ethos of the SFC and the takeovers rules here are not really amenable to it. We've actually given advice previously that it is perfectly possible for Hong Kong listed Cayman Islands companies to go private by way of statutory merger. But nobody wants to be the first cab off the rank to have a go at it because of all of the attendant risks, potentially cost blowouts that might entail getting the SFC comfortable with it, getting onshore counsel comfortable with it, et cetera, et cetera, et cetera. So that's why we're only talking about this litigation in the context of take privates of US listed Cayman Islands companies. So who's actually dissenting and when are they dissenting? By far, the majority of the dissenters are not really aggrieved long-term investors in these listed companies. Very few, if any, are dissenters of that ilk. Most of them are opportunistic investors who will take a shareholding in the going private company just before it goes private, and for the express purpose of dissenting, essentially rolling the dice and gambling on whether or not they will be able to acquire, as a fair value determination from the Cayman Islands court, more money than they would otherwise obtain under the statutory merger. So the big tension in the course of the whole litigation is what is fair value? The dissenter obviously wants to have a large amount paid. It says fair value is substantially higher. These Chinese listed entities are, of course, all systematically undervalued, et cetera, et cetera, et cetera. And when the company in turn will say, well, no, there was a rigorous deal process involved, the price is fair by reference to the unaffected market price or unaffected trading price or bid price, et cetera, et cetera, et cetera. Now, the early victories in dissenting shareholder litigation were for the dissenters. And they would predicate their entire claim on the basis of a DCF valuation, or a discounted cash flow valuation, which is a valuation methodology whereby if you plug certain numbers into the equation, the sum of it can be blown out substantially. And there's, of course, a lot of discretion as to what numbers you put in to work out what the valuation might be, because the valuation is really a present-day valuation based on future cash flows for the company. So it's very, very hard, actually, to come up with something terribly accurate. Having said all that, the early success went to the dissenters using a DCF valuation. But that's changed certainly in recent years. Now, remember, even though there's probably been dozens and dozens and dozens of these kinds of cases in the Cayman Islands, only 5 of them have made it to trial and had a judgment ensue, which means all of the others have settled at some point along the way. And you can infer from those settlements that the dissenting shareholders have actually done better than they would have done had they not dissented and simply accepted the bid price. But what's happened, as I say, in recent years is we've moved away from DCF valuations. We've moved away from dissenter favorable rulings from the Cayman Islands Court. And what we're now seeing is the court taking a blended approach to valuation. So it will factor in not just DCF, which might be as low as 25 to 30% of the consideration, but it would also look at the unaffected trading price and the merger price, the bid price. It would also take a good long look at the deal process and the rigor of that. And what we've started to see, obviously, as you would expect, is more company favorable valuations that are much, much closer to the bid price. So it would be fair to say there's been a slight tail off, but not a significant one in the level of dissenting cases that we've had in recent years. So I suppose that's as far as I need to go, because I've only got a short amount of time to talk about the availability of dissent rights, history and trends. But on to practical matters, what we do, certainly in the litigation context, is to prepare. Mapleton Court tends to act for the company going private rather than the dissenting shareholder. We can advise and provide a lot of early stage advice that's catered to helping the company make it through a contingent claim. So in the event there is a dissenting shareholder, we can put the company in the best position possible to deal with that, whether that means advising in relation to the business combination agreement, taking out wording that's unhelpful, or advising the company in relation to key document retention, identifying custodians, and doing everything it possibly can to be as transparent as possible in the litigation, because a lack of transparency counts against the companies and can penalize them harshly in terms of the determination of the fair value of the shares. And we've seen cases like that in Cayman, where companies haven't played ball as well as they ought to, where they have been significantly admonished. The other thing we advise on is the rigor of the deal process, and making sure that the company is going out there and making sure that what's happening in this transaction is absolutely fair and the best it can possibly do for the shareholders who are being bought out in the circumstances. Other things we can do in relation to the business combination agreement is we can put in various dissent gates. So, for example, if more than 10% of the affected shareholders dissent, if the value of their shareholding is more than 10% by number, then it's a waivable condition for the bidder. They may or may not, or the company may or may not choose to go through with the merger if that is breached. And of course, if it is breached, they have the flexibility of hanging on and not completing the merger until such time as they've dealt with those dissenting shareholders. There's other tricks of the trade which have been implemented over the years, including such things as majority of the minority approval. So in certain circumstances where you have a company where it's a management buyout, for example, they have a sufficient shareholding to drive through the merger just by themselves, a slam dunk merger, as I call it. What we can do to build in protections there is to say, well, okay, we put aside those votes for the purpose of determining whether or not this is going to go ahead, and we will look to see whether, in fact, a majority of the minority or a majority of the independent shareholders also voted in favour of the merger. And very, very helpful in the context of fair value appraisal litigation when you're trying to ascertain to the court or demonstrate to the court what fair value happens to be. So moving on, so I'll leave mergers and merger dissent rights there, given the time constraints. I go on for a long time, and move on to other mechanisms for taking Cayman Islands companies private. Karen, if you wouldn't mind. So there's really only two, and this is much more regionally focused because these are the take private mechanisms that we see, for example, on the Hong Kong Stock Exchange and on the Singapore Stock Exchange. The one we see by far most commonly is a scheme of arrangement. And then what we see in about 10% or maybe 15%, it's a significantly less popular mechanism, is the general offer and squeeze out. So I'll quickly deal with each one of these in turn. So what is a scheme of arrangement? It's a very fancy name for a deal. It's just a plain old deal. It is essentially a deal which is how much will you shareholders of the Listco accept in return for the cancellation of your shares as part of the take private process. So at the heart of every scheme, there has to be a deal. The approval threshold is high and it's awkward. So you only look at the affected shareholders. So for example, if it's a management buyout and management owned shares, they're taken out of the consideration for voting purposes where it really matters. And we look at the affected or the disinterested shareholders. And what we need to drive the scheme through is of those disinterested affected shareholders who turn up to the court-sanctioned meeting to vote on the scheme, there has to be more of them saying yes than no on a show of hands. And of those saying yes, the number of their shares has to be at least 75% of the shares being voted at the court-sanctioned meeting. So not a majority in number of all of the affected shareholders, not 75% in number of shares of all of the affected shareholders. We're only looking at those who actually turn up to the meeting. So it's a difficult threshold. It's been made somewhat more complicated over the years because in the Cayman Islands, we have some rather unfortunate case law where we look through the register to the first layer of custodians. So for example, so account holders through CCAS here in Hong Kong, for example, and we will count each of them on the head count as well if they are voting on behalf of further underlying shareholders. So the problem with that for those implementing the deal or negotiating the deal at the outset is that there's a slight lack of transparency. You've got a little bit less certainty than you'd otherwise have if all you had to look at was the register of members to ascertain who your shareholders are. But why would you want to sanction by scheme? Well, the main reason is because once it's sanctioned, it binds everyone, including those shareholders that don't want the scheme to go ahead. If you get that supermajority approval of the disinterested affected shareholders, then you are going to sweep up those who oppose the scheme of arrangement as well. And this is important because privatization schemes commonly involve a large number of shareholders, some of whom inevitably will object to the price. And we've seen that many, many times over the years. And crucially, of course, the court will not interfere with the wishes of a supermajority of the disinterested/affected shareholders. If they want the scheme to go ahead, if they're happy with the price, then the court will be very, very slow to interfere with their wishes. But it's long been the most popular means to effect the takeover of a Hong Kong-listed Cayman Islands company. It has a lower threshold compared to a general offer and squeeze out, which I'll talk about in a minute. The scheme process is well understood. It's supported by a substantial body of case law going back 140 odd years. It's extremely flexible. A scheme is just a deal. You can build into that deal whatever you want, whether it's conditionality or consideration, whatever you want. It's really what you anticipate the shareholders will be happy to accept for the cancellation of their shares. That's the only consideration from a bidder's standpoint. In terms of economics and economies, it only requires court sanction in the jurisdiction of incorporation of the target company. The Grand Court sees these all the time. It knows how to deal with them. It's very familiar with them. We don't get any crazy stuff. We don't get any delays because a judge doesn't know what he or she is doing. But remember also, of course, a scheme can only be used in a friendly takeover context. And the reason why that is because only the company itself, i.e. the target company, can drive the scheme through the court process. So when the bid comes in, The company's board then has to make a determination as to whether or not it's in the best interests of the shareholders to put that bid to them, to put the scheme to them, and for them to decide. But ultimately, the bidder cannot drive the process through the court. It's really a company decision to do it. The bidder stays in the background, and often the bidder and the company will be aligned with each other's interests, et cetera, and all of that is catered for. But important to remember, it's a friendly means of taking over a target company. Basic structure, very, very simply, the question that all of the target shareholders have to ask themselves is whether they accept X dollars for the cancellation of their shares on the effective date of the scheme. That's the only question they're asked to consider. On the effective date of the scheme, when that cancellation happens, assuming the scheme has been approved, all of the shares of the affected shareholders are cancelled, and then they are immediately reissued to the bidder. And what that does is that it maintains the level of issued share capital all the way through, which means we don't have to go into any of the old-fashioned capital maintenance rigmarole, which we still have under Cayman Islands companies legislation. The schemes are also great from a shareholder protection standpoint. The relevant classes of approvals are limited to those whose interests are aligned with each other, whose interests are not so dissimilar that they can't come together and vote with each other. There's a supermajority requirement, so it takes not just the head count, but the number of shares as well. And ultimately, of course, affected shareholders, should they choose to do so, have the right to turn up at the Grand Court in the Cayman Islands to oppose the scheme if they want to. And as far as we know, in Cayman Islands jurisprudential history, no one has ever turned up in Georgetown for the purpose of opposing a scheme of arrangement. Some of you might recall, it must have been maybe 12 or 13 years ago, the PCCW scheme in Hong Kong, where there were accusations and allegations of rigging the vote or creating extra shareholders on the head count so that it would be easier to drive the scheme through. In that particular instance, people were more than happy to come along to the Hong Kong court and to object, and ultimately that scheme was not sanctioned. So we've never seen anything like that in Cayman, although having said that, if we had a PCCW type situation in Cayman, the court probably wouldn't sanction the scheme in any event, irrespective of whether any shareholders turned up. In terms of time frame for implementation, you're looking at about 8 weeks. So that captures the time from putting together the composite document, dealing with regulatory approvals, and then driving the matter through the court. The reason it's 8 weeks is largely due to periods of time that are required for the convening of the court meeting, the court docket, et cetera, et cetera. 8 weeks, if you can get a scheme done that quickly, is a super fast scheme. Disadvantages of scheme, they're clumsy to deal with, especially if you have a rival bid coming through. You've got this ongoing proceeding in the Cayman Islands court. If you wanted to stop it, there would be some, I wouldn't say drama involved, but there would be certainly some attendances and aggravation involved in bringing it to a halt. There is, as I mentioned, some lack of transparency now with the look-through of the register to look through the CCAS custodian, HKSEC nominees in Hong Kong, or the Singapore equivalent, to look through to that first layer of custodians for the purpose of the head count. And it's a court-supervised process, which means you can never rule out the possibility of a judge latching on to a small point that could be of some insignificance and holding things up. But that's my quick thumbnail sketch of schemes of arrangement. By far the most popular means for the take privates of Cayman Islands companies listed on all other exchanges around the world other than those in the United States. So on to the general offer and squeeze out. I think I've just got a couple of minutes left to deal with this. It's much less popular, but it's much more simple, and its attractiveness is its simplicity. Bidder simply comes along and offers to acquire either all of the shares of the target or some of the shares of the target. An offeror can come along. It does not need, this can be used in a hostile context. You do not need the consent of the target's board, anything like that. The offeror simply comes along and makes the bid. Then, the bid, but I suppose the protection that's there is that the bid has to be a good one, because the affected shareholders are actually truly independent in most circumstances. And you need a large number of them under this mechanism to approve a general offer squeeze out. You need 90% by number of shares of the affected shareholders. So what I mean by that is if you had a management buyout situation where the listed company was owned, say, as to 60% by the controllers, and they were looking to take the company private by way of general offer and squeeze out, the offer would be made to the balanced 40% of the shareholders, you would need 90%, at least 90% of all of the shares held by those 40% shareholders before you could implement the squeeze out of those people who didn't vote, don't care, are dead, buried, or gone away. So it's a high threshold. The other point in relation to general offer and squeeze outs, they take a long time to implement. They're vastly cheaper than schemes. There's no court involvement, but the statutory time frame for them means they take about 5.5 months to implement. So, for example, even when you make the offer and you achieve your 90% acceptances within, say, 2 or 3 weeks of making that offer, the legislation in Cayman still requires you to hold fire for 4 months before you can commence the statutory squeeze-out process. There is an ability during the squeeze-out process for an aggrieved shareholder to try and stop his or her or its shares being acquired, but they can't do it on the basis of fair value. The court will go with the fair value that's been determined by a super majority of the shareholders, i.e. 90% of the affected shareholders. So the aggrieved shareholder can only really attack the transaction on the basis that's manifestly wrong or fraudulent. And again, in Cayman Islands jurisprudential history, we have never had a single claim opposing a general offer and squeeze out. So it's a very, very safe mechanism. It's a simple mechanism. But bear in mind, it takes just about 2 months, maybe 1.5 months longer than a very, very quickly implemented scheme. And as I say, most recently, I just completed the Cayman Islands aspects for the take private of CAR Inc., Cayman company listed on the Hong Kong Stock Exchange acting for MBK. That was all done very straightforwardly by general offer and squeeze out. So it's a perfectly legitimate and good mechanism for taking companies private. All that said, I think I've reached the end of my 20 minutes. So I hand over to Raul in relation to questions.
Hi there. Thank you very much, John. That was a great presentation. I believe we had some questions coming in the Q&A box. And if I can see we have, or Juno has replied, Juno and Karen both have replied to these questions. I'm sure everyone present today can see these Q&As and answers in there. So I guess this is about it. And thank you again, John, Juno, and Karen for your time and for your presentation. And
thanks,
again, if any of the attendees today have questions for the 3 presenters, please email them directly. Their email IDs have been shared in the chat window, in the chat box. And if you need a copy of their slides, we'll be very happy to provide it to you once they get back to their desk and their inbox. So please allow us some time and get in touch with them directly. All right. Well, thank you very much. And hopefully next year we can see all 3 of you in person at an in-person event. Thank you.
Thank you.
Thank you very much.